Good. Well, welcome back, everybody, to the penultimate panel of what, in my view, has been a fascinating conference so far. And this session, I'm sure, is going to be just as fascinating as those that have gone before. I don't want to read through the biographies of the people, of the presenters and the panel members, because you've got that in your packs in any case. And I think we're going to need plenty of time to listen to Judith and to have a good discussion. I don't think that Judith Resnik needs very much introduction. I will just say that she's been a global influence on thinking and debate on courts and adjudication literally everywhere, and in particular on the role of courts in democracies. I think that she's quoted equally by proponents and opponents of privatization, so you cannot talk about it without referencing Judith, and I am delighted to have been asked to chair this session, and I will now give the floor to Judith Resnik. Thank you very much.
Thank you. I'm delighted, and it's a great luxury to have such a crash course of the law that's not only the United States law. And I've learned a great deal, and your staff has been remarkably welcoming and thoughtful. So enormous thanks to the Institute and all who work here. As I started planning this paper, I found myself stumbling over the conversational terms between courts, alternatives. Our panel's called Arbitration. We've got openness, transparency, and privatization. And one could say, okay, here's courts, and there's alternative dispute resolution that includes arbitration, and then talk about the relocation of decision-making outside of courtrooms and into other modes. Well, there are persons who are not. We were just hearing about the appointment of judges who are not judges, who are state appointed. And in some jurisdictions, these judgments can be binding and legally enforceable. And in others, the hopes is that whether or not it's binding, it will persuade the participants to go away and be settling their disputes. And in some sense, therefore, I've described this as diffusing disputes, and therefore disengaging the unity of time, place, and immediacy and process that we heard so eloquently about yesterday. But then I paused, because that sets up a kind of dichotomy between this thing called courts and these things called alternatives, when of course the question is, what is court? Because some of the things that were styled not so long ago as alternatives are becoming part of or all that some courts are doing around the world. And rather than understanding these as alternatives to courts, they're actually replacements of courts and of adjudication. So if one set of puzzles is about what to talk about the processes and how to map them, another is what we mean by openness and transparency. And there's already been some discussion about whether openness and transparency mean the same thing or whether they're referencing something different. Mostly we've been talking about openness in the context of live-time hearings, even if online, live-time hearing on the internet. And we haven't actually talked much at all about the access to the documents, either the judgments produced by courts or the briefs and parties' pleadings to courts, in terms of whether those are open and accessible to third parties. Much of the discussion of openness, with the eloquent commitment to it from Lord Ryder yesterday, is about openness as an accessibility by disputants, and less in focus has been by some openness concerns have been the third party, although the publicity discussion we've been having with reference to Jeremy Bentham, of course, references the third parties as well. And obviously we can talk about transparency. I wanted to focus for a minute about privatization. So one form of privatization is to try to provide privacy for disputants because of concerns about the dissemination of information, again, which we discussed before. Another facet is, of course, the mandated closing of processes. So one is volunteers. Please don't put this out about me. Another is, you must do this in private. And in the US, the word is, there's an acronym, NDA, non-disclosure agreements, which mandate confidentiality. And of course, on the spectrum toward secrecy can be sealing of records and burning of records as well. That's privatization in the context of individual adjudication. But we also, of course, have to talk about privatization as a global phenomenon. And it has a sense of energization movement that may take our eyes away from another movement of the 20th century, which I use the word statusization. It's a little clumsy, but I'm trying to capture the idea that we may take for granted the remarkable accrual of state activities over the course of the 20th century as political and social movements pushed states to be providing not just courts and not just roads, but also social welfare, other economic and social rights from education, schools, healthcare, and the like. Privatization, of course, is the effort to take things away from the state and off the state's agenda and into the private sector, usually argued in the name of efficiency, competition, and the like. And it is a movement that is worldwide. Sometimes it's coupled, but not inevitably, with deregulation. So you can have private sector actors doing what you might call public functions, or other countries call it not so much in the US, but you could have it be highly regulated, or you could have it as part of an agenda of deregulation. Now, there's more to say about all these terms, let alone justice and democracy, which have been much invoked. But another point is to think, why are we in this conversation now? 40 years ago, had the Institute been here and you convened a conference, this would not have been on your agenda as a segment of it. So we are living in an era in which we've already heard from yesterday about a great deal of what I would call doctrinal openness, which we used to take for granted as the thing that courts provided, which was open processes. But we are actually also in an era of what I would call functional privatization, in which much that both courts and their replacements or alternatives do are no longer open to third-party observation. Courts, arbitration, other forms of ADR are all creatures of our own making that are shaped and reshaped through a mixture of political and social movements. And we're in the midst of a political social struggle for the norms about the power of bringing claims, the ability to bring claims, the rules by which they'll be processed and either their merits will be reached or not, about the role of the public and of courts, and about government themselves, and the very goal of whether we should be aspiring to justice. And it's not clear from all political environments that either there's justice is what they want or how they define it. So to reflect a little bit on where we are and what the stakes are, I thought it would be helpful to add some vocabulary from a wonderful law professor in the United States named Mark Galanter, who talked about the idea of repeat players. Repeat players, all of us, media, lawyers, the people who are regulars like governments and large corporate entities and some NGOs in the world, who can play for the rules, who are reiteratively in a process and therefore have the authority to structure it, in contrast to what are called, what he termed one-shot players. Now, I have to footnote, given the importance of law in our world and in our lives, I always worry about game metaphors. But nonetheless, his image of one-shot versus repeat players enables us to see the capacity to not just shape the immediate decision, but to shape the processes by which the immediate decision takes place. And his point also reminds us that we live in a world of resource asymmetry. So although England talks about equality of arms, we are absolutely not in that setting in the litigation or anywhere else, inequality, of course, being a signature of this decade. Now, of course, we're also not the first to think about these problems. And Jeremy Bentham has been much invoked, but he hasn't really been described for what he was, which was an early proponent of ADR. He was very much committed to undoing and revising what he saw as the quite terrible processes of the common law against which he railed. He talked about his version of repeat players were judges and company, by which he meant lawyers, whom he described as developing common law rules that were for their own self-interest. He was wonderful in many ways, and the legal system they created was as thick a mist that one could not, if not in the trade, get anywhere. The artificial rules of the common law produced a factitious practice full of procedural obfuscation that cost clients and the public. Civil courts were thus shops at which delay was sold by the yard as broadcloth was sold by the piece. So he was a big ADR proponent, and there's many things he wanted to do. unlike the wonderful tree image with which you began us, he said there was nothing natural once justice moved inside. He was very concerned about the architecture, his referent being buildings, and he understood that choices were always made. What was it he advocated famously? So now there's a little bit of PowerPointing. As soon as I can do this, we've invoked it, so we should see it. Publicity, the very soul of justice, of course, which he's famous for. Why his insistence on openness? What did he understand to be the utilities and politics of it? He had several agendas. First was a claim we've already heard for truth, that if we were all in public, we would ferret out the lies among us. Second was education, and here he thought the theatrical was good. Schools, courts were both schools as well as theaters of justice. He thought that judges would naturally want to explain what they were doing, and of course we all have already adverted to the disciplinary power. The more strictly we are watched, the better we behave, and therefore his half real, half imaginary tribunal of public opinion would assess. He was going to enable a competent public to therefore sit in judgment of the people who were giving judgment, and by inference the state itself. He was also concerned about state control of information, so he proposed auditors and ever-seeking incentives. He thought he might need to pay them. We've all assumed there'd be an audience watching what courts would do. He was less confident about that, so he wanted to give them an opportunity and pay them and hope they'd take minutes or notes. He didn't call them bloggers, but we would, so that there would be dissemination without it going through government channels. Now, we've talked a lot about concerns about privacy. Bentham wasn't an untempered publicity person. He talked about institutional publicity, but he was keenly aware of the needs for personal privacy, and he had a whole list of factors about when you could close courts that looked just like the factors that many of the courts sitting in this room that we know use, as well as his arguments for openness, although he's not always footnoted as the reference for either one. Now, his concerns led him to be something else, which was kind of an egalitarian, although he thought that natural rights were nonsense on stilts. His utilitarianism sought to involve the public writ large. Nicola Lacey has a wonderful essay about him as a proto-feminist as well. But he was also described as thinking that, he wrote, filing fees were a tax on distress. He wanted an equal justice fund. So he was for access to justice before we used that phrase in quite that way. And he wanted to subsidize the cost of legal assistance. He wanted to subsidize the travel. And he wanted judges 24/7 and on a budget so they could produce decisions quickly. And he was deeply innovative, but he was also really a creature of his time, as are we all. And here's the reminder that 100 years earlier, and now I'm trying to bridge the Atlantic by quoting from a founding document of the English colony of West New Jersey on my side, in all public courts of justice for trials of causes civil or criminal, any person may freely come and attend. This is 100 years before Bentham's publicity, and after the U.S. Revolution, the U.S. states took this proposition to heart, and I'm giving you little excerpts of early constitutions of both the state of Connecticut and of Alabama. This is the 1800s. All courts shall be open, and every person shall freely have come and attend, shall have a remedy by course of law. Of course, we're indebted to the Magna Carta as well. Over the course of time, with the political energy and the professionalization of judges and lawyers and architects, we all went to governments and were able to produce funds for separate, segregated buildings. We take for granted the word courthouse. There used to be townhouses or multifunction. We've got our own dedicated buildings with special budgets for them that are here, and I've given you an adorable example from Connecticut from the early part of from the 1790s that is still in 1780s that is still functioning now, that represents this, which became not only a signature of law but also of governments themselves. Now, I'm using this to make a point that although it's dear, it also helps represent the disjuncture between Bentham's times and ours, which is that the buildings that house courts are no longer of this size. And the questions that occur, because Bentham lived, obviously, although he might have wanted dissemination of minutes and he had a printing press, he didn't have our internet, is whether the publicity that he sought courts provide was really something that we need today in a world that looks so different from this building. A vivid example of the availability of information without courts comes to the United States from a movement we call Me Too, and which I take in French as balance ton porc, and I don't know the German, but I assume there may be. You have a parallel to come, which is the ability to directly tell your stories on the internet. And in the United States, the disclosure of sexual predatory behavior and people saying Me Too has generated collective action that has had force in the sense of some, not just individuals being fired, but some institutional restructuring. And Me Too isn't the only example. In the United States, we've had sad, horrible examples of police brutality through the videos. And there's also been videos of airlines dragging a passenger off a plane. And we talk about this as going viral, which at one level describes easy information exchange. At another, it also gives us an image of the potential for contamination. Because what this also references is the idea that information can spread in a way that is infectious as well as inventive and generative. And so Bentham's had a cheerful version of his tribunal of public opinion, with its own self-interests understood, not manipulated, aggregating preferences, and enhancing the general welfare. Our experiences are not of a public, but of publics with an S, that are fractious, divided, angry, hostile, do or do not understand their welfare as we might understand their welfares. Who is the we who's speaking here? And we're looking at the notion of a multiplicity of points of views. Art historians teach us that Cubism broke the linear plane. We no longer have a singular perspective of the Renaissance. Critical theorists make this point repeatedly as well. So Jeremy Bentham is not only relevant to those of us who seek the soul of justice. Jeremy Bentham is relevant to public relations, propaganda, and advertising, because they understand his lessons as well. And we no longer think about only information, but misinformation, disinformation, false facts, manipulated, too much publicity. Before we left the States, the New York Times had a whole story about how on social media people make up their followers. You can buy followers and then become more celebrated than you were because you have a fake set of followers who are twittering, who are in theory following your Twitter. We also understand what I would call a predatory public, which is to say appropriation of individuals' identity and imposing harm. We see tensions, therefore, between free expression, free access to information, and privacy. And of course, here, Google Spain, much invoked already, is a signature of the idea of the need to be balancing, under the European traditions, ideas of public information and right to know with personal data that can be taken off the internet. 4 points emerge from Google Spain, famous 2014 decision from, I guess, across the street almost. First, it does underscore the harm that free information can impose on individuals who are subjected to it. And it reminds us that while courts were open and public, they had what some term a practical obscurity, which is to say you had to go there. And in terms of documents, you had to know what was in a file and go find it. There is no practical obscurity in this web search. Second, therefore, Google is a way of organizing information, which is to say it's a virtual communicative space forming the possibility of democratic or non-democratic public opinion to be formed. It doesn't just stockpile information, it organizes it. So Google, like courts filter and organize information, so does Google as well, although maybe in service of advertisement as well. And courts were advertising their own importance, but not advertising our information. Third, Google is not just a stand-in for the function of courts and for dissemination, it is a court. Since Google Spain was decided, Google and other web platforms are tasked with figuring out whether to take down information. We know from Google that it created an ad hoc advisory committee for rules. We heard about advisory committees before, that as of 2017, it had processed more than 700,000 requests, and it had taken down about 40% of them. 4, Google isn't just a court, but it's a private court. Because I just told you what I know because Google told me this, but I don't know anything else because Google hasn't told me anything else. And whatever it decides to tell me is all it is that I get to know. Unless I know under European law, if Google rejects, I can appeal to national privacy data, so I get some information that way. There may be some media reports. Of course, as a repeat player, Google may have an interest in delisting sometimes. We have to figure how Google actually implements the Google Spain directive and figures out the balance of privacy and public information. We can't know. And therefore, an important part of European law's practice and implementation is being developed by webmasters without public engagement or debate about how to write or rewrite the balance. And so then, returning to Bentham, looking back, totally admiring of his brilliance, we also have to understand that he was innocent in some dear way about what the public was and how information would flow. But he isn't the only innocent. So were all the brilliant inventors of the web who a decade ago didn't really foresee or describe much hackers and appropriation and the terrorizing of information and the large-scale invasion of health and finance records, the controlling streams of information, and of course influencing and potentially corrupting and undermining elections that are in theory democratic. So in addition to being too optimistic about understandings of publicity and information and control and the publics and the technologies, we've also been, I think, taking for granted and celebrating, which is nice, both statization and also courts as egalitarian institutions. And here I just want to show you a picture from a courthouse in the United States in the 1930s in Aiken, South Carolina. Federal money going to this. The artist who did the image of this virtue of justice, a long, iconic representation of justice, a female figure, often with scale and swords. He said, none of that. I'm just going to use the red, white, and blue of the U.S. flag and her symmetry to talk about justice as protector, avenger, supposed to be behind a brand new courthouse in Aiken, South Carolina. And in walked a member of the press, who's been invoked here, who said, a mulatto wearing bright-hued clothes. The federal judge who was to sit in front of her said, this is a monstrosity and horrible, and wanted to get her out. Both federal and state officials discussed whether to remove her. The artist, let's go back for a minute, said, I didn't mean any political statement with her dark skin. It was a problem of the pigments, and I'll repaint her. There was a controversy in which the National Association for the Advancement of Colored People came in along with a bunch of artists, and you'll see the curtains. The denouement was that she was enclosed in curtains because in the 1930s in the United States, a woman image perceived to be dark skin could not stand in as a representation of the virtue justice. This description and her closure, of course, reflected the closure of our law to women and men of dark skin in the 1930s. And although when the U.S. Supreme Court got its first building of its own in 1935 that said equal justice under the law, it in fact didn't provide the kind of equal justice that we think of, as of course it must have provided all along. So one of the great successes of the 20th century was to make this seem so bizarre to you that I have to dredge it up from our archives, when in fact it was the normal course for courts to be exclusionary. And while the 1818 constitutions of Connecticut and Alabama could echo the Magna Carta and say every person could be here, that every person wasn't all of us in the room, but a small segment of them. Now, of course, the political, economic world and social movements have changed. So if you come here to Delaware from the 1990s, it amended its constitution to say every person, him or her, his or her, can come in to mark women's arrival. And of course, as we look at this in a world in which we now worry about gender dichotomies, we're not so sure that the pronouns work as well as they once looked like they were in the 1990s. So when Bentham wrote, courthouses were not open to all of us, employees could not call to the account their employers, and prisoners could not challenge their custodians or vulnerable people, as in European language, the abuse within their households. These new rights and these new activities, these political movements, turn courts into what I would call democratic venues, with a particular meaning of the word democratic here, which is to say that judges and participants have to treat each other equally and civilly inside courts. That's been true for a while, but all of us weren't there. So courts become not just a school for education of the authority of the law, but they are real-time democratic iterations of what it means to have to be treated equally in a polity. And on this account, Bentham talked about it being schools for us. I think of courts in their democratic as having to be schools for the government, which has to understand that it is being engaged, watched, understood, and has to be taught again and again that it can't exercise its power without observation, explanation, and the like. It's got an obligation. The rights, R-I-T-S, of earlier centuries become rights, R-I-G-H-T, and we in the public become empowered. Now this changes the depiction of adjudication, which is typically shown as a triangle, a judge with two sides. And I want to talk about a square because the participants include the public, which has not just an entitlement to be there, but a kind of obligation to be a part of the process as well. And so the other piece of this is that I've just told you in all these different directions, from Google Spain to equality movements, that law is not fixed, but is constantly, iteratively being engaged and changed. And what another part of my concern about the privatization of process is, one is it's changing and we don't know how it's changing, but the other is we don't have much input into which way to push it or not. But the fast track simplifications, about which we've heard some of and we'll hear more, assume a kind of law as good as it is. And all I got to do is get the forms and the apps and punch in the buttons and we can all exchange. But I don't know whether the law is good as it is. And I don't know about moving it in all the directions. And if all I'm doing is punching in forms and having fast tracks, I don't have a way to understand whether I'm in alternative dispute resolution in or out of courts, whether or not I want to move the law, and if so, how to make this happen. So now turn to another facet of the impact of 20th century rights in courts, R-I-G-H-T, openness in the sense of getting there and openness in the sense of watching, which is to say that we know that there's been a wealth of information about courts and a wealth of users. The success of the 20th century is the production of a volume, and I've just given you a snippet from the United States. U.S. federal courts are very high visibility and very low in the volume. They have about 350,000 cases a year, civil and criminal, and about 1 million bankruptcies. State courts have 40 to 50 million filings every year on tort and family, and if you take traffic and criminal, you're looking at about 100 million filings a year, which is to say a remarkable success. People understand this as courts that they can come to and they can use, but also as a remarkable challenge. Democracy did not just change adjudication, it's challenged it fiscally, because of course the demand is enormous for this kind of service that the government is providing, and therefore resources are challenged. This brings me to another facet of how publicity can work for judges as part of their political economy, which is that judges, I know all this data because courts report it. Why do courts report it? They report it because they're trying to get funding from their coordinated branches, and they need to document that they're very busy and they need more judges and activities and buildings as well. And so we have to talk about the political economy of courts as we understand this activity. Now, the political economy of courts has been very successful in the federal system in getting lots of funding. But on the state side, it's been enormously challenging. And they've gotten, although the political will should be there, which is a big question about how we could raise more of it, funding for courts is a problem. And so what I'm giving you is a snippet from the Illinois Task Force. Access to justice, Bentham, access to justice now, access to justice in England. How are we going to figure out how to do it? Well, one of the things courts do is raise fines and fees. They try to self-fund through user fees, and we've already heard both the UK Supreme Court has recently held that the remarkable increase of user fees in the employment tribunals was an unlawful increase because it so cut use. The Supreme Court of Canada has a similar judgment around these issues. So we in the United States are in the midst of a large amount of litigation, much of it class action, collective litigation, challenging the discriminatory impact of fines and fees on people of color and on poor people in general. And I just have samples, and there's more. It turns out you have to pay to file a defense as well as to file a pleading in some of the states in the United States. So if you sue me, I can't file unless I can show you that I'm poor without paying $435 to answer in some ways. And of course, filing fees are the very thin slice of much more expensive attorneys, experts, and the like. And so I want to bring into view something about U.S. adjudication that is much less seen, which is that in the federal system, our rich, beautiful courthouses that have been built, about a third of the people who bring cases have no lawyers. On appeal, it's more than 50%. In the state courts, one large study found that in 80% of the cases, at least one side was not represented, more often the defendant, because there's a vast amount of creditor litigation, which is to say that we're looking at a vast amount of poor people trying to use courts without any of the expertise that's in this room. In addition, there's not much adjudication. In a state court, in a study of state courts, fewer than 4% of the cases have anything called adjudication, including court-annexed arbitration. In the federal system, we talk about a vanishing trial. Out of 100 civil cases filed, one will start a trial, if that. And so we are seeing a decline in public processes. And the third facet, which makes the first two seem kind of makes it invisible, is in fact the reason we still see high visibility of a lot of litigation is because we have collective actions. And it is not the individual poor people who are able very much to manage, but it's through collective actions, which is class actions and something called multi-district litigation, that we have a great deal more resources. In the federal system of the pending cases, a third of them are in aggregations, so that they are proceeding not as one by one, but actually are grouped together. And thus, you can see that the real activity is dependent on group-based litigation, and now coming back to the repeat players that both Bentham knew as judges and companies and which we know as a much wider set. Our repeat players in the United States are playing for the rules to prevent aggregation, some of them, and to keep aggregation, some of the others there. Now, John Rawls famously talked about a veil of ignorance for his theory of justice. Procedure makers have no veil of ignorance. They are trying very hard to make rules in their interest. Some judges and lawyers may be dispassionate, but a whole lot of their people are being lobbied, not by dispassionate, but by passionate advocates on both sides. So one version of the lobby is producing. This is a federal courthouse opened in 2000 with its 29 stories. But if you go to the web of the federal courts that welcomes you, you can't see it. This is the web shot. To avoid the expense and delay of having a trial, judges encourage you to reach an agreement. Go away. Please do something else. Don't use this building and its courtrooms, but instead settle. Local rules that implement this say in every conference, judges, when you ever meet the lawyers, you're to please say you must try to settle your case. You should try to settle your case. It's the wise and good thing to do along the way. And so when you look at these rules and you think all we've been discussing about third parties and the like, and my square, I've careened through hundreds of rules in the United States about alternative dispute resolution inside courts and outside courts. None of them write in the public. To the extent the public's there, it's a caution. Keep this confidential. Do not provide this information outside the circle of the conversation along the way. That's not inevitable. British Columbia and some other jurisdictions are paying attention, but we're looking basically at a system that is closing inside courts as well as out. So here you look at this gorgeous, we're in this is a Harry Cobb building. I know we're in a Meyer building. Meyer's also designed courthouse in the United States. Gorgeous carefully made courtrooms. There are 4 equal arches for the public, for the plaintiff, for the defendant, for the judge, all equal before the law, carefully stenciled. What do we know in that court? We know that filings are declining and trials are declining, so that we're looking at a flattening file rate and virtually no trials take place. Maybe those courtrooms are used a little bit for non-trial activities. Maybe they're used 5 or 6 times a year, if that, for trials. So what does one of our wonderful federal judges say? The image of a judge behind the bench is simply obsolete. Look at me behind a computer or talking to people on a phone. We're an endangered species if you're thinking about us in the old garb. That point is made again by a recent volume on online dispute resolution. It's not a very good graphic, but what I wanted you to see was all the little pictographs are all about, first of all, celebrating the judge behind the computer, not worrying about it. But second of all, they're all about either the disputants or the judge, and we, the rest of us, are not in the picture at all. So inside courts, where are the parties who I've argued are intrinsic in a democratic adjudicatory process? Now come for a very brief moment to outside the courts, which is under the U.S. system. In the 1920s, heavily influenced by Europe, our Congress enacted something called what we call now the Federal Arbitration Act, which says that you're going to enforce obligations to arbitrate, and it preserves the law of contracts and exempts the workers who could have been subject to it under then understandings of federal congressional authority. So for the first 50 years of its use, and here's an excerpt from a 1950s case, the interpretation of it would look familiar from European eyes. It only applied when there was equality of bargaining, and it only applied because we worried that arbitration was informal and flexible and not rule-obliging, and we were using adjudication, litigation, as a regulatory mechanism to enforce the obligations of the state. But starting in the 1980s, the U.S. Supreme Court reread the statute. The statute didn't change. The court changed its jurisprudence. And it made enforceable these obligations not only when there's equality, but here's one. I know you can't read it very well. Waffle House, America's place to eat, America's place to work. Eric Baker signs this form. What does it say? First, it says, don't eat the waffles, and if you take anything, we can give you a polygraph. And second, it says in teeny print, so my print size here replicates, but you can maybe read it, you're bound to use arbitration, and you, employee, and we, employer, split the costs, and it's exclusive and preclusive. Baker has a seizure at work, and after he signs this form, and he goes to the Equal Employment Opportunities Commission that screens the case and says it looks like they violated, the company has violated America's with Disabilities Act rights and its discrimination, and they file a lawsuit. And the Waffle House says, I'm sorry, this form means that you, the Equal Employment Opportunities Commission, cannot get any back pay for Baker because he signed that form. The U.S. Supreme Court decides, with a dissent, that this form does not bind our federal agency, which has a statutory duty, and therefore it can proceed. But the court has since used forms like this to preclude employees from bringing their cases directly. And now my next form, again, a terrible graphic. It comes from our cellular phone service. And it's a bad graphic because you can't read it. It's a great graphic because there's no point in reading it because it's neither negotiable nor negotiated. I called up and said, excuse me, you're taking me out of all class actions. Now you very sweetly say you can't bring a class action against me. I'm touched by that symmetry, but I don't want this form and I still want your service. And they said to me, sorry, take it or leave it. So I'm not using the word contract here or agreement here because it is neither negotiated nor negotiable. But unfortunately, the U.S. Supreme Court has held in 2011 that it is enforceable. So now California and many states said, of course it couldn't be enforceable. Sounds familiar from this side of the Atlantic, because you're exempting, the party has control, can prevent litigation against it. But the U.S. Supreme Court said, no, 1925, the U.S. committed itself to arbitration, and these mandated waivers of arbitration are enforceable against and can include prohibitions on collective actions. Now here's a current, you can find this on the web. We may change any terms, conditions, rates, fees at any time. Although the courts rationalize themselves by saying that the reason that it's binding is because I consented, I do not think I've consented to a contract. The other argument for it, which is very current on both sides of the Atlantic, is it's great. It empowers individuals, freeing them from reliance on lawyers and making dispute resolution easy and accessible. This is the effective, better, more paths. Arbitration is great. And I'm not talking about large-scale arbitration. I'm talking about individual consumer arbitration. So I said, okay, I want to understand this. California requires consumer arbitration providers to put information on the web about what they do. The American Arbitration Association is very upstanding and complies. Many don't. And so we can get 5-year data downloads of all their consumer arbitrations. Across the United States in a year, from the American Arbitration Association, there are only about 1,500 consumer arbitrations a year. And we culled all the data to try to figure out, some great law students and me, helping, overseeing, culled to try to figure out how many times individuals brought arbitrations. And we used AT&T because it was the case that was the ban. And what did we find? Basically none. AT&T had between 85 and 150 million customers, 145 million customers over 8 years. And we could find in the database fewer than 60 individual claims against the company over that time. And the Consumer Financial Protection Bureau looked as well for loans for credit cards and the like, and have exactly the similar parallel data, which is that there is not much brought. Now, one answer is no need. All these companies are completely law compliant. We don't have any claims. There have been federal regulatory actions that belie that. Another is the company settles, so there's no need, and I would say certainly settles some. But the more logical explanation is that it's really hard to do it alone. It's very hard to be a solo actor for a small value claim. It's also, I've read all the arbitration rules. They make actually our court rules look pretty clear in terms of figuring out how to proceed. And then when we go back to the informal paupers fee waivers, they're not easily accessible in terms of this, and it costs a filing fee, even though the major American Arbitration Association will not let the employer charge the employee or the consumer provider charge the consumer as well. You may think that what I've just told you is America exotica, unwise, exceptional, or the like. But we're in a world of transatlantic repeat players who play for the rules. And in playing for the rules, what we're looking at is, of course, the growth of collective action here, as people have commended in many parts of the world that class action-like activities have usefulness, although they don't use that term, they use collective action. And what do we find? The same U.S. Chamber of Commerce that has worked so hard to not make it feasible to do it in the United States is working very hard here. A new monograph from last fall warns about this, tells you that there are significant inroads, that there are unregulated industries, that the U.S. style, we're here, worry about exporting. And I just want to make the counter worry. Yes, the U.S. can be exporter of both potential models of class actions as well as models of opposition to class actions. And I know that the court in the Schrems case and others are debating what the shape of collective action should be and what the European rules should be. So I want to come to close by just underscoring the themes of this question of the political economy of procedural rules and the roles played by repeat players, century-old calls for reform, and the functions of publicity and privatization. And I want to talk about the political will for collective action. The popular image, which I've just reinforced, is it's all about consumers, little people in the U.S. class actions for discrimination in the 1960s. That's true. But collective actions are not only in service of individual actors, but can be in service of corporate and government interests as well. Governments because they need legitimate decision-making, and repeat players because some of them want global peace. So the real invention of collective actions in the United States wasn't in the 1966 class action rule, which is the thing people worry about here, but in the 1950s, Central Hanover Bank brought a case to the U.S. Supreme Court. A case came involving them. New York State wanted to make it easy to pool trusts. Why? Banks wanted to take small little amounts and put them together, but then they worried that although they might be useful for the investment opportunities they provided, all of us beneficiaries could then bring claims individually against the bank. So they invented a procedure by statute under New York law called the settlement of accounts, which was a kind of declaratory action that would come every 2 years, and the bank would be declared prudent, and none of us could then bring claims because you'd buy res judicata through that process. Individuals said, wait a second, you didn't give us good enough notice, and excuse me, you're New York State and I live in California, how can you reach me? And the U.S. Supreme Court, in an opinion in the 1950s, said, wow, it's really important for the vital state interests of the growing economy that we reinvent, they didn't quite use those words, they used vital state interests as the word. We need to change our procedural rules. We need to re-understand the due process clause, both to authorize New York to settle the accounts of anybody who's got money in the state, change our jurisdictional rules, and furthermore, you have to give notice. Now, as a consequence, you have to give notice to the affected absentees. The U.S. class action rule built in notice to affected absentees. The folks who oppose class action say, let me show you, very few people show up to protest. Notice isn't worth it. Class actions are bad. What I want to say is, notice is a form of Jeremy Bentham's publicity because it forces to the public the deals that are proposed to settle these large-scale claims. And so collective actions and resources have to be part of a conversation about publicity and openness and justice. And as we think about the structure and function of our rules and figure out public and private, we need to build in opportunities for ways to understand law. I'm returning and closing. This is the pictogram in this volume on alternative dispute resolution. And this is the impoverished pictogram because it doesn't build a fourth part into the story. And if we want to be able to debate what's just and what's courts and what's a good rule of law, we have to have more than the internal dispute of this set of participants. Thank you.
Thank you so much, Judith. It was tremendous lecture, huge amount to think about. You got through, you covered an enormous amount of ground in a relatively short space of time, and gave us many things to reflect on, which I hope we can pick up in the discussion. So we've now got 3 discussants, and we're going to take them in the order they're listed on the programme. So I'd like to introduce, first of all, Professor Maxi Scherer from Queen Mary University of London. Thank you.
Thank you very much. Well, my turn to thank the organizers for putting together really what is a wonderful conference program. I've enjoyed the entire 2 half days so far, and I hope you'll enjoy the rest of it. But I also wanted to thank Judith for an absolutely inspiring lecture. I have to say, I just listened and thought I should write down everything. My task is to give much more mundane, I'm afraid, comments on the relationship between transparency and arbitration. I'm going to pick up where Judith left it with her, I think, very forcefully put, and rightly so, concerns about arbitration being used in what I would call unequal settings between that involve consumers, that involve employees. And I think all of us here in the room should think about this carefully. There are attempts to to implement that on this side of the Atlantic. And if we hear carefully about what Judith said, we should think about this again. Now, I'm going to talk about a different form of arbitration. I'm going to talk about commercial arbitration between commercial parties that are, technically speaking, on an equal level, and investor-state arbitration, an investor on one side and the state on the other side, where here the question of inequalities maybe will come in. And I'm going to pick up on a number of things that you said at the beginning about your definition of openness or transparency. And I was extremely happy to hear that you redefine transparency not only in access to justice or publication of decisions, but much more broadly involving also the third parties in your square, the sort of last angle. Because that, I think, is extremely important. I've tried in a recent publication to define transparency very broadly in a way to say it is about access of information and exchange of information between the players of arbitration and others. Now, who do I mean with players of arbitration? Well, obviously, it's the parties. It's their parties' representatives. It's the arbitrators. And it is potentially an administrating institution like the PCA, the Permanent Court of Arbitration, ICSID, the ICC, and others. And I think it's that exchange of information between the insiders and the outsiders that I would call transparency. And importantly, there are both ways. This is not a one-way street. The transparency in that exchange of information can be either from the insiders to the outsiders, and that is what I would call outbound transparency, or the other way around, which I would call inbound transparency. Now, let me give you a couple of examples to be a bit more concrete. Outbound transparency obviously is first of all about the specifics of the case. In a confidential setting, there is no information that should come out from the insiders to the outsiders. I sit on commercial arbitration cases. I'm not even allowed to tell you who the parties are, where they're from, what the dispute is about. It is entirely private and confidential. Then there are cases where there is a minimum amount of information that is given to the outside. For instance, we know that the Swedish nuclear power provider Vattenfall is suing Germany for its decision to phase out of nuclear power. But we don't have access to the filings, and we don't have access to much information about what's going on there. And then you have the full-fledged, full transparency in certain arbitrations. One that my firm was involved in is the so-called ABA arbitration. That was what is now South Sudan. It was then the South Sudanese Liberation Army /movement and the Republic of Sudan. And it was about delimiting the borders of this region, the ABA. And here you have everything on file. You have the pleadings, you have the decision, you have every single minute of the hearing, if you're really bored, on the website of the PCA that you can watch. So that is the full-fledged types of outbound transparency from the insiders to the outsiders. Now, what is maybe less known and what we less think about is the inbound transparency, the information that is given from the outsiders of the arbitration to the insiders. What is this? Well, first of all, obviously, these are potential what we call amicus curiae. Non-governmental organization, other non-disputing parties then can give information to the arbitral tribunal and to the parties. And this is hugely important because in some instances, the parties do not have the information or do not want to give the information to the arbitral tribunal. So having amicus curiae in those positions is inbound transparency that I would think submit is actually quite important. I would also submit and put in that category of inbound transparency scholarly writing. The fact that we as scholars actually screen the decisions of the arbitral tribunals and analyze whether there is a consistent jurisprudence or lack thereof. And I think it's that context given, provided from the outside that can also be quite important. And then I would add maybe another category, and this is not about the specifics of a dispute, but about the system as a whole. And maybe this is another black box. We talked about black boxes in the previous panel. And that is, who sits as arbitrator? How many times do people sit as arbitrator? Where do they come from? And here again, there has been quite some criticism about the arbitration mafia. Few people being appointed as arbitrators. And being part of that mafia, I can tell you it is a small group of people. And so there is a growing trend, and I think very important growing trend, of making statistics available, not only about geographic origin, gender balances, etc., but also who actually sits concretely in which case. If you look at the ICC's website, you see in which case, Mr. So-and-so sits with Mrs. So-and-so, etc., without obviously the parties' names. Now, this outbound and inbound transparency, I don't have time to go through this. I would submit has been growing tremendously over the year. Wherever you look into NAFTA, you look into ICSID, you look into commercial arbitration even, there has been a growing trend of more and more transparency. And the rationale here, of course, specifically if you think about investor-state arbitration, is because there is public interest involved. First of all, there's taxpayers' monies involved. The respondent is a state. So yes, it's all our taxpayers' money if that state needs to pay damages. But it's also because the interests involved concern energy supply, energy security, environmental issues. So these are important questions that the public wants to know about. Conversely, however, think about that is not so much true necessarily about commercial arbitration, where you have two commercial private companies in a contractual setting exchanging, contractual disputes. So maybe here the quest and the need for transparency is much less. This leads me sort of slowly in my final thoughts about a critical assessment on the transparency. And I think here I would just briefly say, we've heard a lot about Bentham and the accountability point, and that he said it was important, transparency was important to discipline the power of the judges. Well, that potentially is even more so important in arbitration, where the arbitrators are first and foremost accountable only to the parties. And so the question, how are arbitrators accountable to the public as a whole, is actually really, really important. And my colleague, Catherine Rogers, has put together a project which is called Arbitrator Intelligence. It has sometimes been described as the TripAdvisor of arbitrators, which I think is not quite right. But the idea is there's information available on arbitrators, how they actually deal with cases, how quickly they render decisions, that is available to the public as a whole. And so the accountability of arbitrators, the emphasis here is really important. It also helps to foster, hopefully, the legitimacy and trust in the system. We all know that investor-state arbitration is hugely criticized and under scrutiny at the moment. And the fact that decisions are available, hopefully trying to be more consistent, I think will help. The transparency here will help foster the legitimacy. And but we shouldn't forget that with all these possible advantages, there are also downsides to transparency. And I couldn't agree more with what Justice O'Leary had said in the earlier panel, that it's not an end in itself. And one of there are two possible downsides that I see with transparency. The first is arbitration in certain instances has actually been conceptualized, and the idea was to depoliticize certain disputes, investor-state disputes in particular. So making disputes more transparent has the potential of escalating these disputes in a way that all of a sudden a reasonable settlement will not be possible again. If you remember what Advocate General Spirner said at the beginning of this conference, that when there is a camera in the room, the parties do not plead to the court, they plead to the public. He actually said, I wrote it down, this is a show to the external world. And that makes in complicated, political, sensitive disputes, makes a reasonable settlement actually more difficult. And so we also need to think about that downside. And the other downside is costs. Judith mentioned the potential difficulty, filing fees to get access to justice. Now, organizing a public hearing is costly. Organizing the filings of making all the filings available to the public is costly. Now, in arbitration, who actually bears those costs? The parties. It's a contractual dispute. It's only the parties who can pay for it, at least, unless someone thinks about a different system. So if the claimant has to pay for that, it is an additional hurdle for bringing a claim in an investor-state arbitration or otherwise. So we also need to think about these downsides, potential downsides of transparency. So again, I think a balanced approach here is important. And I should not, close without mentioning that there is, of course, the very important Untitled transparency rules that have been put together, and the Untitled, the UN Convention on Transparency. And what they've tried to do is precisely to allow that balance. There is a lot of information under those rules in arbitration that will be available. The entire pleadings, the names of the parties, what the case is about. But there are certain things that the judge will need to, the court will need, the tribunal will need to decide on, in particular if the exhibits are somewhat sensitive, have commercially sensitive or state interest sensitive information in there. So I would be able to talk about those rules forever, but I'll stop here. Very, very looking forward to the comments of the other panelists here on the panel. Thank you for your attention.
Thank you very much for that. Perhaps you might say something later on about the cost to a common law system of the loss of precedent in private arbitrations, which is something I don't think you did mention, but is a big issue for some people. Certainly something I'm concerned about. Moving on, then, we now have Dr. John Sorabji, who's Principal Legal Advisor to the Lord Chief Justice and Master of the Rolls in England and Wales. He's also a silent writer of many speeches of judges, which we know. So very interested to hear what you've got to say on privatisation.
Thank you very much, Hazel, and thank you as well for the magnificent presentations we've had so far, and also for the panel this morning. Before I start, I make the usual disclaimer that I'm not speaking on behalf of anybody else. These are just all my mistakes I'm about to make. Taking as my starting point Jeremy Bentham. A long time ago, very long time ago now, I was a philosophy student, and we had to study Jeremy Bentham and his acolyte J.S. Mill. And in the world of philosophy, Jeremy Bentham is very, very dull. And in fact, he just isn't where the action is, philosophically speaking. It was only when I moved over into law that he became interesting. As Judith has demonstrated, I think, with great aplomb today, there wasn't anything that he didn't say that wasn't pertinent in terms of the justice system and the way we view courts and tribunals. His idea that judges and lawyers were, as he put it, fraud and co, not just judge and co. Fraud and co was one of his polite terms for them. Demonstrates a certain degree of skepticism that is sometimes healthy to have, although perhaps not to that degree. Turning to the substantive points, I want to make a number of points about the tension that Judith highlighted between access to courts, access to open courts, and to privatization of courts. Now, my focus will be England and Wales. Not that the UK or England and Wales is an island unto itself, but just because that's my experience. You could construct an argument that from the early 1980s, there has been a move towards a degree or a form of privatizing or privatization of the courts in England and Wales. The starting point would be a well-intentioned report by an organization called Justice, which in 1982 introduced the idea that litigants were consumers. Now, it did so in the sense that litigants should be treated well when they go to court. They should have good service. Court staff should treat individual litigants in the same way that they would be treated if they went to Marks and Spencer's or Harrods. They should get good consumer service. Now, from well-intentioned ideas like that, and it's an excellent idea, and we still have to really reach the point where litigants are given a good degree of service in the courts. And I think that's a general point. That's not just an England and Wales point, that's a general point. We have moved from that idea to the position last year, towards the end of last year, where the Supreme Court has to give a lesson to the public on the view that actually litigation is not a consumer product, that litigants are not consumers, and that courts do not provide a consumer service. They are a fundamental aspect of the state, supporting democracy and the rule of law. So you can trace through, and if we had more time, I could trace through for you, the various steps that we have gone through since the 1980s, where from Justice's initial report and its well-intentioned recommendations, we've moved to the point where the state views or there is a view within the state that courts simply provide consumer goods to individuals who litigate in front of them. It's just another product that you're purchasing. The second strand to this argument would be the move away from the funding model for litigation. Jeremy Bentham talks about a litigants' fund. It was the proto-legal aid scheme. We've had legal aid schemes since the 1940s. Again, since the 1980s, we have seen the winnowing away of legal aid, and we have seen its replacement by private forms of funding. The state, as Atlas, has been shrugging its responsibilities, if we can call on Ayn Rand from the other side of the Atlantic, in terms of legal aid. We have now in the UK, in England and Wales, various forms of conditional contingency fees. We also have third-party funding, which I'm sure the US Chamber of Commerce is particularly concerned about within England and Wales. That was supposed to be introduced on a statutory footing. The statutory provision to render it lawful has never been brought into force. The courts themselves relaxed restrictions on third-party funding. And then, so we see a move from the idea that the state has responsibilities to the idea that individuals and private enterprise should take the responsibility. The third strand is court funding. At one time, the courts were funded on the basis that the state paid for court funding and that the litigants' filing fees subsidized the state. In the 1980s, that was reversed. And now it is the state which subsidizes the individuals. The civil courts are supposed to be fully self-funded. Where that funding does not meet requirements, the state steps in, the taxpayer steps in. So there you see a philosophical shift in the idea of the role and the importance of the state and its responsibilities to the justice system. It is just there as a backup. It is not there to provide the main means of funding. So again, you could see that we move towards the privatization, the idea that the state doesn't have a primary responsibility. And of course, as soon as you make this philosophical shift, other things flow from that. If the state is only there as a backup and individuals are supposed to provide the fees, the funds themselves, then what else does that entail? Again, you are moving towards the idea of a consumer-driven model. It is one model for the delivery of justice. It is one model, just as ADR and its various methods are equal models, you could say. And that takes me to the promotion of mediation and ADR, something which has been occurring with great rapidity since the 1990s. The Wolf Report in 1995, we all know it. The primary philosophy of litigation is settlement, not adjudication, but settlement. So why? Because it's just as good. It delivers just as good a resolution to disputes. And we see from there, we see the move to the Michael Briggs report from, I think, 2013, where the courts, in their case management functions, are no longer to manage cases to adjudication. The role of the court and the role of case management is to manage cases to resolution. And resolution can be any which way, either adjudication, mediation, negotiation, conciliation. They're all viable and equally valid things for the court to do. And of course, if we take this stance, we move to the position, as Judith very rightly noted, that we move our courts away from the idea that they are schools of justice. They are not schools of justice in the sense that a number of disputes are being hidden from sight. We are losing them from public view. So not only are we not developing rights, but we are not highlighting where disputes are arising for the public. They are being lost. So there are a number of strands that we could see in terms of privatization. Now, against that, there is an equal strand which is seeking to reform our courts on the basis that we reinvigorate access, we reinvigorate openness, that we reinvigorate the idea that the courts are a pillar of democracy, which I think possibly has been mentioned a number of times already. And we see this primarily at the moment through the digitization of our processes within the civil courts. Now, some people have said that all we're doing is making an old-fashioned paper-based system operate on a computer, so nothing fundamentally is changing. All you're doing is changing the vehicle through which you deliver justice. But in fact, the digitization of our courts, and particularly the creation of our online court or online civil court, carries with it the potential to create greater openness and greater accessibility, to actually bring more disputes within, more issues within the public gaze. And there are three ways in which it can do this. And I'm just conscious of the time because I don't want to take up too much time. The first way is through what we could say is the promotion of preventative law. In that way, disputes, if they're issued online, they're on computer files. Through the use of big data, for instance, information can be extracted from those files to highlight where specific legal issues are coming up time and time again. Now, if you have that capability through the use of the online system, that information in an anonymized way, so there's no data protection problems, in an anonymized way can be provided to ombudsmen, to regulators, to provide what was possibly described yesterday as a feedback loop between the courts and between other aspects of civil society, to bring those areas of dispute into the public gaze through providing them to ombudsmen so that there can be systematic review, there can be publication, public debate. So it brings disputes back into the public gaze, and as a result of that, through preventative measures, through recommendations, those types of disputes can be diffused from actually even arising, hopefully, so diffused in a different way. The second method is through rendering access to the courts much greater than it is at present. Access for small consumer claimants, particularly those who enter into contracts using eBay or Google. Their disputes at the moment are dealt with by eBay, by Google, etc. They are dealt with by algorithms rather than people, in the main, I believe. They are, if I can quote very badly or modify very badly, a song from the 1980s, they are making of those individuals slaves to the algorithm. If you get the song reference. Maybe you don't. I'm showing my age. But those individuals who at the moment have no basis of coming to the courts, okay, it's fine. If you have a genuine choice and you don't mind your dispute and you're happy for your dispute to be settled by eBay, etc., by all the other online dispute resolution mechanisms, that's fine. But if actually you want to have a genuine choice, you need genuine access to the courts. Now, revising our courts so that they are digital in the way they deliver justice is one way in which we can try to bring those disputes back into the courts. But equally, for those individuals who at the moment have no access at all, there is a reserve army of disputes which never reach the courts, which historically have never reached the courts. By rendering access greater through cheaper, more easily available digital mechanisms, issue your claim on your smartphone, for instance. Everybody has a smartphone these days. We open up the potential to bring more disputes within the framework of the courts. The final point that I make is that just tying into the very final point in terms of collective action, and this is going off the point. In collective action in the UK, we only have one real collective action mechanism. It was introduced, it was reformed 2 years ago. There have only been two mechanisms, two actions brought under it, neither of which have got further than the initial certification stage, and neither of which have got past the certification stage. As a mechanism to increase access to justice, it appears to be one that you don't really need to worry about at the moment because it's not actually doing what it was supposed to or intended to. If we want to increase access to justice for the small single individuals with economically unviable claims, collective actions, class actions really aren't where it is in England and Wales or the UK as a whole. What it may be, the mechanism to go forward, is greater digitalisation of the courts and access through online mechanisms. Thank you.
Thanks very much for that, John. I think we might come back to the question of the extent to which digitisation is going to increase access to justice in the final roundtable. And finally, we come to Anna Koprivica, who's from the Max Planck Institute here in Luxembourg, who's going to give her comments. Thank you very much.
Thank you. Good afternoon. It is my honor to be a discussant on a panel with such distinguished speakers and to be granted an opportunity to give my modest contribution to this contentious issue of the privatization of justice. Now, given that I'm the one closing this round of presentations, I thought it would be appropriate to actually pick up on some of the main issues raised by all the speakers and to try to map out the various processes of privatizations that were addressed, while throwing in some European examples just to kind of give the comparative perspective, and of course outline the questions that these processes raise. And I will do so without referring to Jeremy Bentham, just for the sake of a difference. So to that end, drawing on what has already been said in previous presentations, I would like to note two distinct sets of privatization processes that we can observe here, that was actually already referred to by Judith Resnik. And the one that, on one hand, we have for what I would call, for the purposes of this presentation, privatization within courts, or the internal privatization, and on the other hand, the so-called external privatization, or relocation of disputes outside of courts to private entities. So when talking about privatization within courts, I'm in fact talking about what Professor Resnik referred to as functional privatization of court-based processes outside the courtroom, but not outside the state in a way. So in other words, this denotes the privatization of processes through deploying such modes of operation within court that render the contents and the outcomes of these processes practically inaccessible to the public. So I use this term privatization very loosely here, the private actually referring to the absence of publicity, the public knowledge of these processes. So because I'm also very aware of the time, I will just provide you with some examples to make this very concrete. An illustration would, for instance, be what we addressed yesterday, and that is the virtual non-existence of oral hearings in certain types of proceedings, such as in, to take the European example, the European small claims proceedings, but also we heard in many national courts in civil proceedings, this is very often the case. Of course, we could use privatization in this sense to refer to those situations where the court decides to close proceedings in order to protect the privacy of parties. Some types of proceedings are almost always confidential to an extent or closed, such as disputes involving intellectual property, for example, due to their nature. Similarly, as we heard also from Judith Resnik, privacy sometimes required by non-disclosure agreements in the US or confidentiality agreements in Canada. And finally, one example may well be the institution of negotiation deals that we heard about yesterday from Katrin Gierhake in criminal proceedings. But the point I actually want to make is that while on one hand we witness the rise of this privatization within courts and its processes, and which results in the removal of these processes from the public eye, on the other hand, what we witness is the trend that goes in the opposite direction that we heard from Maxi Scherer. So in those areas where some of the traditionally confidential and even obscure, as referred to it, mechanisms operate, such as investment arbitration, today we see this clear push for more openness and more transparency, very much similar to the functional, and I would say even doctrinal openness, again to use your terms, that the courts are typically associated with. These parallel phenomena are sometimes referred to as judicialization of arbitration and arbitralization of court procedure. And although the notions themselves are very often criticized in literature, I find it very interesting to observe that some procedural features that are inherent to court adjudication, traditionally, penetrate some forms of arbitration which are traditionally perceived as confidential, while at the same time, those very features tend to disappear in certain areas of court adjudication activities. So in fact, this intersection of the traditionally public and traditionally private could be also seen in Cécile Chenet's presentation yesterday on civil proceedings, where she used the examples of the ICSID proceedings in order to take it as a potential lesson for national courts. Now turning to external privatization, or privatization, the relocation of disputes to private or semi-public entities, I will borrow the definition here from Judith Resnik. The process of privatization in the context of courts in this case refers to the allocation of power between courts who hold sovereign monopoly over dispute resolution and the private sector, the non or the semi-public actors. In business lingo, we could also refer to this phenomenon as outsourcing. And outsourcing is generally defined as a business practice used by companies to reduce costs or improve efficiency by shifting tasks, operation, or processes to an external contracted third party for a significant period of time under the justification of there being advantages both for the outsourcer, being the state in this case, and the outsourcee being these other entities. And although compared to the situations in the US and the UK, I would say there is still a high proportion of civil disputes actually dealt with in courts in Europe, one can observe the tendency in judicial policy making towards external privatization in certain areas of law. Therefore, what I would like to try very briefly, without going into much detail, touch upon some European examples of external privatization in order to demonstrate the existence of this trend. So the motivations behind the decision, which tasks to outsource to which entities can be different. The function that those entities perform in relation to courts can be different. They can be preventive in the sense of diffusing disputes and therefore actually avoiding going to the court dispute, which is generally the goal of reconciliation and mediation. They could either complement the judicial powers in the sense of simply being an optional ADR mechanism, such as commercial arbitration, for example, or in form of actually assisting courts with their tasks by undertaking some preliminary or preparatory actions, which is sometimes what the notaries are dealing with. Or they can almost entirely replace it, which is our greatest concern here. So the decision to establish external privatization can also be determined by specific and comprehensive expertise in some matters that were formerly dealt with in courts. So for instance, in matters of succession, in many member states, it is precisely the notaries that decide in these cases, such as in Hungary and Czech Republic. Another example would be the adoption of a decree in Italy, which introduced competence for Italian lawyers to perform an in-house separation in cases of non-contentious divorces. In other cases, the decision of outsourcing some tasks may be a strategy for allowing courts to actually focus on their core competencies. An example for this can also be the debt collection activities in Hungary, where this is outsourced to the notaries. But one can also think of the consumer ADR regime here as disputes that typically, although not always, involve low value claims. So finally, in light of this, I would also like to note two developments within this type of external privatization. So on one hand, we can observe the increasing trend of externally outsourcing certain types of disputes, typically small value claims, which involve different kinds of litigants, consumers, individuals, employees, to extrajudicial bodies and subjecting them to extrajudicial processes. On the other hand, we are witnessing a competition among courts today in the European judicial area in the wake of Brexit, in particular in the areas of financial and commercial law and patent litigation, with an aim to attract big litigants and become competing judicial hubs through specialization. So some examples would include a few German courts in Düsseldorf, Mannheim, and Munich in the area of patent litigation, Frankfurt is a very recent development, as well as the establishment of the Netherlands Commercial Court and the introduction of proceedings in English at the Rotterdam District Court, which is supposed to deal with maritime and transport law and international sale of goods. These two developments combined raise some important questions. Could this kind of specialized court proceedings, which combine best practices of commercial arbitration, but still stay within the state adjudication, could they potentially slow down the processes of external privatization of disputes? Are these judicial initiatives representative of what Judith Resnik refers to as statization? Taking a step further and looking at the big picture, one may wonder if this kind of specialized court proceedings, coupled with the aforementioned developments in the area of privatization, challenge the traditionally perceived role of courts in today's society. We had a question at the very beginning, what is a court today? And if we understand adjudication as performing a number of important individual and collective social functions and democratic venues that guarantee equal access to all, and institutions which apply norms established in the name of the whole society to individual cases, then the question is, how does that reconcile with the current trend of privatizing significant section of that adjudicative function to the mechanism that are either unscrutinized by the third parties, by the public, or even unregulated? Yesterday we heard about the package deals, I think they're called in criminal law in the US, that are not regulated. And more importantly, these processes are not committed to the same standard of the rule of law. Consequently, is the mere fact that this form of privatization retains adjudication within the state system, so stays within the court, doesn't make up for the potential loss of the guarantees relating to court proceedings? Are the processes of privatization of disputes a concern for the rule of law and access to justice? I don't have the answers to the questions. I'm just raising things here, and I think these are questions that merit our attention. But I would just like to conclude by saying that I don't think privatization of dispute resolution, or at least not in all areas, is a problem in itself, and it is certainly not stoppable. At this point, it is something that will continue to exist and develop in various forms and shapes. It is an inevitable consequence, as we heard, in the surge of number of litigants and opening the courts virtually to everyone and different categories of court disputes. The courts have become sort of a victim of their own success. But the problem is rather the manner in which this privatization takes place, and I think this is something that needs to be reflected on, and the questions of access to justice. So to finish off, I would actually like to recall one part of Sir Ryder's speech of last evening. He said, "It is one thing to accept that there is a public interest in the promotion of settlement." I would add any other ADR or anything else that's the alternative or a replacement to courts. It is, however, quite another to accept that such disputes are not or could not be made capable of being brought before the courts. So thank you very much.
Thank you very much indeed. I just had a depressing vision of European jurisdictions taking what remains of our litigation from the English courts. What a thought. We've got very little left in the courts, but it's all going to go to Europe post-Brexit. Good grief. We've had tremendous presentations, and that's one of the reasons why I wasn't cutting people off, but I'm aware that we're running out of time. Do you want to have a little bit of time for some discussion?
I would propose that Judith should get a moment to make a remark if she wants to make it. We will have the panel discussion, and I think we can pick up some of those points. Yeah.
No, I'm
so
fine,
Judith, do you want to write a...
No, thank you, fine.
Okay, so is this time for a coffee break then, and then we come back?
I would say we had a very nice first coffee break. Of course, it was a long session. I would like to ask you to make a break of 10 minutes sharp. Please take a coffee, come back, have a coffee inside. After the conference, there will be plenty of time for you to discuss, but we still have a very interesting panel.
We do.
We have not very much time.
So can we just thank again this panel? Thank you very much indeed.